Good morning and welcome to today's webinar. My name is Amanda from CCIQ and I'll be facilitating today. Joining me is Jason Wales, General Manager of Workplace Relations and HR Services here at CCIQ. Today's webinar is on Workers Compensation Advisory Service. As an employer, it can be daunting when an employee sustains a workplace injury or illness. Jason will highlight some common questions that they receive through the Workers Compensation Hotline and support tools and resources available to help business owners protect themselves and their employees. If you do want to ask Jason a question, you can do so at any time using the chat box that appears on the bottom right-hand side of your screen. I'll now hand over to Jason to take you through today's presentation.
Thank you, Amanda. Hello, everybody. I hope everyone is having a great day today. It's a bit hot outside here in Brisbane and it's been hot for the last few days, so I'm looking forward to a cool change coming soon. But once again, thank you for tuning in to the webinar today. As Amanda pointed out, today's webinar is more about the Workers' Compensation Advisory Service, the free service that CCIQ provides to every employer in Queensland. Through this free service, we are able to provide general advice on anything to do with workers' compensation and rehabilitation and return to work. So how did CCIQ come to provide this service? Well, quite simply, we've been provided a grant and some funding through the Office of Industrial Relations, and the aim of the grant was to bridge that gap between work cover, the Office of Industrial Relations, and employers, particularly in dealing with sensitive issues. It's difficult to get an independent and independent advice when it comes to work cover and claims. So the idea of the grant was to provide funding to an independent body to provide members of the business community and employers independent general advice around workers' compensation. So CCIQ was successful in receiving that grant funding, and we have been doing this, providing this service, I should say, for just on 5 years now, I think, Amanda. So it's been a long-term, priority for us, and we take a lot of calls from every industry type in Queensland and support them through their workers' compensation inquiries. The service is available, as I said, to every employer in Queensland, regardless if you're a CCIQ member. This free service is available by calling 1300 365 855, and you'll get to speak to one of the team, be Robert, Jacinda, Michael, Monica, or myself at times. And the team are very experienced industrial relations practitioners who provide you with general advice. I just want to reiterate a few things as we go through this presentation, that our advice is free and independent of work cover and the Office of Industrial Relations. So we don't report back on specific claims. What we do is listen to a situation, provide advice, and we document the nature of the call, the category and subcategory, the advice provided, location, industry type, and how long we spend on managing an inquiry. And that's the reporting mechanism for the grant. So there's no names and no specific mention of the claim itself, no claim number, etc. What we can do is we can call work cover on behalf of an employer and just ask general advice regarding a specific claim if we have a claim number. But we don't report that back to the Office of Industrial Relations, and it's only on rare occasions that a caller or even a member who might use the service as well would want us to do that, because sometimes there's a bit of a misconception that the big brother is watching, and the more information or the more questions you seek could get you into trouble. But rest assured that we are independent and free of any intrusion from work cover or the Office of Industrial Relations. So yeah, we've been doing it for a very long time, and happy to assist employers throughout Queensland with their general inquiries. Our team take a call, and we respond to a lot of calls. I have listed here on the slide the categories and subcategories that we get the most inquiries about. So I'll start with responding to an application for workers' compensation. It's amazing to hear these calls come in, because a lot of businesses still find it difficult to lodge a claim, in particular who is responsible for lodging a claim. And we know from the processes and policy with WorkCover that lodging a claim is the responsibility of the employer, and it's also the responsibility of the employee. Some businesses jointly lodge the claim. So an employee injures themselves, they go to their responsible line manager or owner or workplace health and safety officer, and they might lodge a claim together online. But either one of the parties can lodge the claim independent of the other knowing. And in some scenarios, which we've experienced via the helpline, an employer will get notification without even knowing or understanding there's been an injury that's been sustained in their business, and it's news to them at times. So proactive management of staff is something we always want to enforce and reiterate when it comes to even HR matters, and of course workers' compensation, workplace health and safety. If you are across your team's movements and whereabouts, and your management staff are as well, there should be no surprises when you get a claim for workers' compensation. In saying that, the claims decision process, we do get a lot of calls from frustrated employers stating, how the hell does WorkCover make a decision based on the evidence we provided? There's a lot of factors that get taken into consideration when a claim decision is being decided. So, and we can go as far as employers saying it's nonsensical. How do they come about this? But I'm not here to make any judgment on the claims decision process on behalf of WorkCover. I'll be here just to reinforce what we provide in terms of services. Another good question we get is payment of wages and leave accrual. Who pays for wages, and what happens in particular when an employee injures themselves and a claim has been lodged, and the gap or the time period between the lodgement and acceptance of the claim, and that time period there, who is responsible for paying of wages or sick leave? So we get a lot of calls on that. So if that does happen, when a claim is lodged and WorkCover is still deciding on accepting or denying that claim, you are responsible for paying that employee's sick leave benefit or whatever entitlement you've decided on until such time as WorkCover has notified you of the decision. And if they have accepted the claim, then there will be some conciliation of leaver balances and money that will take place once the claim has been accepted. One thing we do get a lot of inquiries on is how to dismiss an injured worker. It's not as easy as it may seem to dismiss an injured worker, because we're bound by legislative requirements, and that is an employee cannot be terminated within 12 months of sustaining an injury and being on workers' compensation. So if you're ever going to or are considering terminating an employee while they're on WorkCover, I suggest you give us a call and seek some guidance and advice on what that might look like for you in terms of risk, and of course, if you're allowed to do it. A lot of employers, from our experience, are frustrated when it comes to employees that aren't participating fully in a rehabilitation return to work program. They might go AWOL. They might be, going fishing on the weekends and exacerbating their injuries. Those kind of things can tip an employer to the edge of, I want to dismiss this employee. We are mindful of that, and we are here to help in those situations, but we are bound legislatively as employers not to dismiss an employee in 12 months of being on WorkCover. But that's not to say there's no there's workarounds, I should say, that we can address on each particular case. So best you give us a call if that ever happens. So okay, moving along to rehabilitation issues. Um, Suitable duties plans, medical certificates and restrictions, and host employer arrangements are the big ones that we get in relation to rehab issues. Most employers understand that there is an obligation to provide suitable duties if someone has sustained an injury in their workplace. What most employers don't know is that if you can't facilitate suitable duties in a return to work program, there's other businesses out there who can provide that for you. All you need to do is contact WorkCover or your case manager and advise them that you're not in a position to facilitate suitable duties or rehabilitation, rehabilitation plan, and they can arrange a host employer to take on that responsibility for you. So don't feel like you have to. If you can't, just simply call your case manager at WorkCover and ask if you can arrange a host employer to take over that suitable duties and rehabilitation part for you until the employee's back on their feet and able to come back into your workplace on their pre-injury duties. I've highlighted in bold here in particular, there's some changes, legislative changes that take effect from the 1st of July 2020 in regards to rehabilitation and return to work coordinators, which every employer in Queensland will need to be aware of. And I'll talk more to that further on in the slides. But lodging a review of an insurer's decision is something that gets a lot of inquiries, and as employers going through this process, understanding that you do have avenues for recourse if you don't agree with WorkCover's decision on acceptance of a claim. There are things you can do and steps you can take to question that. And one of those is always seek the reason for decision document in any WorkCover claim that's been accepted. The reason for decision document spells out the thought process, the evidence, any other bits of information WorkCover has used to determine that a claim has been accepted and is valid. So it's important you understand that document is available to you. So always seek the reason for decision document with any case. Review that document, and if you're not happy with the decision, you can seek recourse through a review of the insurer's decision. The team here at CCIQ can help you through that process. It can be a little bit daunting when you're going up against Godzilla, you might say, but there are steps and there's a process involved, and there are resources and people to help you through that, but always seek that review of the decision. I'll talk now to some of these slides about some of the questions that we face, and they're quite general. However, it can never be general enough in terms of providing advice, and it's all about understanding the fundamentals and basics of any bit of legislation or obligation you have as an employer. So I'll just talk through a couple of questions that we always get, and there are still businesses out there who don't have an insurance policy with WorkCover, and you can get into trouble, you can get fined. In our experience, WorkCover always happy to work with an employer who have not had a cover, and they will work through that with you. But yes, if you're an employer in Queensland, you do need to have a policy. Your responsibility when it comes to an injured employee at work, there's a few of them. I've just pointed out 3 here. If someone injures themselves within your business, you have a legal responsibility to notify WorkCover. Previously mentioned, employee or an employer can lodge the claim, but best practice tells us that it's best to do it together. That way you understand what's going on and you're taking control of the claims process. Situations arise and difficulty happens when an employer is not in control of the claim, and an injury might have happened on another site, or they were an employer is not made aware of an injury and they get notification through WorkCover and the employee hasn't come back to work. There's no in those situations, there's no communication between the employer and the employee, and you don't want that to happen. You want to always engage with your employee through this process in order to understand the information and be in control of the claims process. If I could just stress the importance of communicating with your employee through this process, as we get many calls where employees are on workers' compensation for extended periods of time, but have not communicated one bit to the employer. That's through no fault of their own, of course, but it's just so important that if the injury has happened in your workplace, as an employer, you take control of that process, lodging the claim, and be on the front foot when it comes to speaking with work cover and understanding medical restrictions and the suitable duties position, and really take control over it. While we love our employees and we value them and they are an important part of our business, there are the odd few that will take advantage of a work cover claim. And one way to combat that is be on the front foot always with workers' compensation claims and injury management. I'll just go to the next one now. I think I've talked a little bit too much about that one, but I can go on forever. What are my responsibilities if the claim has been accepted? Work with your employee and work with the work cover on any element of the claim, such as rehabilitation and suitable duties. And not every employer has a suitable duties plan, or even has a rehabilitation program, or even a health and safety policy. But it's important to understand that you must work through the suitable duties process with your employee and with work cover if there is a claim. As mentioned before, if you can't provide suitable duties or rehabilitation opportunities within your business, then work cover can arrange a host employer in your local area that will take your employee on. The host employer could be in a different industry altogether, and the employee could be doing another role that they're not trained for. However, the ability to be functional and contributing to rehabilitation is what the host employer program is about. Excuse me. You should also notify work cover if you pay any claims expenses, so they can reimburse you for them. For example, if you paid for a medical appointment or any bit of treatment, you have to notify work cover of that, because that's something that can be reimbursed. What are my rights as an employer with a claim? If you have any concerns about the claim, you're to notify work cover. And I might sound like I'm repeating myself over and over again, but the more you communicate with stakeholders in this space, the better off you will be, and the more informed you'll be when it comes to managing your claim. If you feel like you're not getting the best out of your work cover case manager, you can always request to have another manager take over that claim. And if the claim has been accepted, you can lodge or seek a review of the insurer's decision. Always seek that reason for decision document. That'll assist you in making any further claims with work cover about their decision. If you feel like your employee might be taking advantage of the process as well, you can raise that with your case manager, and your case manager should work with you in determining whether or not the facts that have been provided by the employee and their medical practitioner are actually true. How a claim is approved or denied. Work cover gathers information from the worker, doctors, and other stakeholders, such as occupational therapists and other practitioners, and when making a decision. The onus of proof is placed on the employee to prove that they had a valid claim for injury, and work cover has to take all that information on board when making a decision. It's important to note here that as an employee, you don't need to sit back and wait for WorkCover to provide you with information. Once a claim has been lodged, I urge you to start investigating the claim yourself, looking at if you have injury reports or injury notification reports, injury reports, looking at camera footage or CCTV footage, talking to other people in the business that may be aware of a certain incident or injury in the business. You start to investigate that first. While the employee has a right to lodge a claim, you have a right to defend that claim. So don't rely on WorkCover saying to you that you've received a claim and that we've got all the evidence we need, we're going to proceed with the decision. You have the right to submit any documentation, any supporting documentation, evidence to that claim that will, prove either the claim was sustained in your business or it wasn't. So that information is important when the claim is being decided. So please submit all the information you have regarding a particular claim or an incident, and that will be used by WorkCover in deciding whether or not the claim will be accepted or denied. Please don't sit back and don't submit anything, because you will might end up with a claim being approved where you may not want it to. So the onus, I believe, on you to, as a business, to ensure that claims are valid or denied is entirely up to you as businesses. So take the opportunity to investigate yourselves. Suitable duty plans are those plans we use to facilitate rehabilitation into the workplace. And these days, in modern workplace practices, suitable duties and rehabilitation is so important. WorkCover Queensland, the Office of Industrial Relations and Workplace Health and Safety all work together to strive to get people back into work. Programs such as the Injury Prevention and Management, IPAM, from Workplace Health and Safety, and the Office of Industrial Relations communications and message in line with WorkCover is getting people back to work has a better return on business than someone who's off. So if it's in your capacity, even if it's not, try to develop a suitable duties plan that will see your employee come back to work on limited duties or varied duties to help them facilitate return to work as quick as possible. The host employer thing pops up all the time when it comes to suitable duties plans, and I think I've spoken enough about that at this point. I'll skip this slide because it's once again it's going on about and providing you with information around host employers. If you need more information around host employment, what that means, you can either go on the web page, WorkSafe Queensland, or give us a call if you can, and we can provide further information as well. Yes, you can get a review, and I urge you to get a review if you're not happy with the decision that WorkCover has made. WorkCover are a wonderful bunch of people, and the organisation has some great resources and great people working for them, very skilled and very experienced in the area of claims management. And here at CCIQ, we work with WorkCover on a lot of programs and a lot of initiatives designed to educate and facilitate small business employers on managing claims. There are opportunities and avenues out there for a small business to seek a review, and all you need to do is follow the process that they set out for you. And I urge you to do it if you're not happy with a decision. So when it comes to the process around lodging a review, you must lodge that with the regulator within 3 months of receiving the decision. Employers should use the 3 months wisely to gather their information. Every bit of information helps. Witness statements, notifications, and any internal processes that you have in managing a claim will all come in handy when submitting information for a review. Grounds for review vary. You might want to question the insurer's decision in the fact that they might have you might not agree with the doctor's statement or independent medical review. You might have some new evidence that's come to light around the employee's motivations for possibly lodging a fake claim for workers' compensation, or you just know that they played cricket on the weekend, broke their finger trying to catch the cricket ball, and you know that the claim has been falsely lodged. So there's different reasons that you might want to seek a review, but I just want to enforce once again, if you feel aggrieved or you feel the case is not genuine, then you have that opportunity to seek review at any time within the time frame allotted, of course. Possible outcomes of a review, and I put a lot of questions around the review in the presentation today, because it's one of the topics that we get a number of calls on, and it's important that we understand that when you do seek a review, you do have another avenue. If the review doesn't go your way, you can seek an appeal. And the appeal would be a final decision when it comes to that claim that you're fighting. And once again, the appeal must be filed within 20 business days, and the appeal decision is final. It's a long process, and it will take time and energy to correlate all the relevant bits of information. But once again, if you're certain and you feel like you need to go to the appeals process, then there's avenues for you to do that. So always keep that in mind. No, back in the day, you used to be able to get that, but that's changed. So I just wanted to point that out. But you used to, back in the old days, get an opportunity to see someone's claim history, but you can't do that now. Something around understanding grounds for discrimination is where that comes from. So employers do have on application forms, are you fit for duty, and are there any restrictions or any issues that prevent you from carrying out the inherent requirements of the role you're applying for. A lot of application forms have that component in there, but they can't specifically ask these days if there's for your work cover history or an employee's previous work cover history. The Rehabilitation and Return to Work Coordinator, there's some changes to legislation which I'll talk about further on, as I mentioned before. But you do and you don't. Depends on the size of your business and, of course, the earnings of your business, whether or not a return to work and return to work coordinator is appointed in your business. Work cover will pay most things in the claim, and it's important to understand that work cover, as your insurer, will always communicate with you about who gets what in terms of payment, and work cover will reasonably cover costs for medical treatments related to the injury, and also compensate the employee for their lost wages. Work cover will only approve treatment by a registered or approved provider. Work cover provides a table of approved providers on their webpage. Then I urge you to have a look at that as well. So these are the high risk industries according to the ANZ SIC standards. And it lists, from 1 to right down to 7114, but I don't think that's an appropriate number. But anyway, list of high risk injuries. So of course, agriculture, forestry, and fishing are one. Mining, manufacturing, construction, road transport and storage. Miscellaneous, as you can see there. But this is what work cover considers as high risk. And if you're in one of these industries, it's important to have a workplace health and safety management system and an OH&S system that supports mitigating risk and facilitating rehabilitation and return to work and safety of employees. Okay, changes that are taking effect from 1st of July 2020. Rehabilitation and return to work coordinators. From the 1st of July 2020, employers must provide the following information to their insurer. Details of who their rehabilitation and return to work coordinator is, and a statement of how the rehabilitation and return to work coordinator is qualified to perform the role. So if Jason is working for Bob's Butcher and he's the nominated coordinator in that business, Bob's Butchers will need to provide work cover with a statement to show that Jason is qualified to perform the role as of a coordinator. For further reference to this, please see the attached Workers Compensation Rehabilitation and Other Legislation Amendment Bill 2019 explanatory notes. And that was a bit of a mouthful for me today. But please refer to that document and read through the changes that will take effect from the 1st of July 2020. And I can hear some of the questions, or I can hear some concerns already, and that is, how do we know, what courses will be deemed, suitable? And we met with WorkCover last Monday to ascertain what courses and who will approve courses, and are some courses not going to be of the standard. And WorkCover is working through a list of providers and courses that will be made available to employers, so they can, put their coordinators through courses that WorkCover have deemed to be fit for qualification. So and of the standard. So watch that space, and refer to the 2019 explanatory notes for further details and more information on that change. Another thing, unpaid interns from the 1st of July 2020 will have coverage under workers' compensation in the event of an injury, which is a good thing. You don't want someone coming into your business and they're injured that they're not going to get compensated at all. But I understand that this is something that is bringing up a lot of contention as well. But I'm not going here to debate legislation. Rather, I'm here to provide you with the context of what's happening in the space. So we'll look at some specific information now about resources to help small business. There's a link there, and you can click on and find more information and resources. And I'll just move down the timelines now. Time to lodge a claim, very important. If I was to ask anyone in a room how long, what's the time frame for a claim to be lodged, I'd get varying degrees of responses. But within 6 months from a date of injury is the time frame. And 20 business days from receipt of a claim is the approval process, or the review process. So in that 20 days, WorkCover will be seeking information and using that information to make a decision to approve or deny a claim. And after that claim has been decided, the employer has 3 months to seek a review of the insurer's decision. Resources are available to you and other small businesses and businesses within Queensland to help you navigate the mind-boggling field of legislation in regards to HR and workplace health and safety. CCIQ template store has policies and procedures that are in Word format. You can download and manipulate to suit your business. There's comprehensive guides such as the safety management, return to work checklists, and many more. If you're a HR assist or people manager member, there is a discount available to members. But if you're with a HR assist package, then we provide you with a comprehensive library of resources that form part of that membership. Workplace Health and Safety in Queensland. Their web page is notoriously hard to navigate. So when you're looking for something on WorkSafe Queensland's web page, I suggest you use the navigation and search boxes. It's really handy when trying to find a specific information on that web page, because it factors in 3 business units such as WorkCover, workplace health and safety, and the Office of Industrial Relations. So it's a big web page with a lot of information. So using those navigation toolbars and search boxes will prove in your best interest. So things you can find on those on that web page are risk assessment tools, information on safety, hazards, health and wellbeing guides, and Serious About Safety business pack, which is very, very good. And I suggest you click on that link and get that pack if you're a small business owner. Invaluable. IPAM is another great resource and a free resource for businesses in Queensland. Workplace health and safety, you know, a lot of people get scared when they or hesitant to contact workplace health and safety. They have a small business unit designed to support small businesses with workplace health and safety and becoming compliant. The IPAM program is designed to support small businesses in reaching a level of compliance. And on a practical sense, what that means is you can contact IPAM, or if you're a member of CCIQ, we can refer you on to IPAM, and they'll have offices throughout Queensland. They have a team of advisors who would come to your business and provide you with free resources and tools to get you into a compliant workplace health and safety space. And the program can last anywhere up to 12 months, where they'll coach and guide you and mentor you into a level of compliance. And they sit outside the inspectorate, so there's no fear of being turned in or dobbed in to the inspectorate side of the business, because that's not what they're there to do. Their sole purpose is to stop you from getting fined and stop you from injuring someone. So a wealth of knowledge and free resources in the IPAM program. CCIQ and my team work very closely with IPAM in delivering education and resources to businesses within Queensland. And we're looking to hold an event in Cairns late next year, around June. And we'll, look to provide, those businesses in Cairns with some resources, tools, and best practice advice. We had an event in Toowoomba 2017 with around 75 or nearly 80 people turning up there, and we had an event in Mackay last year. So we're going to have an event in Cairns next year. That's with IPAM, WorkCover, and ourselves. So we work collaboratively to support small business through HR and, of course, workplace health and safety and workers' compensation. Yes, minefield of a web page, but the benefits are wonderful when you can find out what you're needing. CCIQ has training platforms, online training platforms for businesses to access as well, and they're designed to, I'm sure, of course, to have a level of compliance. We have some member offers available to our members relating to free courses and upgrading as well. Thanks for listening to me go on today about workers' compensation. I just want to convey the importance of workers' compensation and injury prevention, and why, while it can become a minefield, just know that there's someone out there that can support you with regard to anything workers' compensation and rehabilitation, return to work, and it's totally free. Call us on the workers' compensation helpline 1300 365 855, or email workcoverinfo@cciq.com.au. You don't have to be a member of the chamber. It's a free resource available to every employer in Queensland. So please tell your network of businesses and your friends that there are tools and resources there to help businesses with these issues. And if you have HR matters, please give us a call at 1300 731 988. That concludes my presentation today. I'll hand you over to Amanda to finish off, and I have a safe and Merry Christmas and a even better New Year's. So be safe, and we'll talk again next year.
Excellent. Thank you very much, Jason. Thank you for everyone who's tuned in today. We'll send out a follow-up email later today with a link to the recording and also some links to some of those websites that Jason referred to earlier and a copy of those explanatory notes for the legislation amendment bill. So thanks again. This is our last webinar for 2019. Thank you for joining us, and we wish you all a Merry Christmas and look forward to having you join us in 2020. Thank you.